Good evening. I'm Louise Petering, League of Women Voters of Wisconsin Board President. Welcome to this opening event of our 2021 annual meeting, the first of 3 virtual gatherings that close our state league year. With our theme, Strength and Diversity, Partnering for Progress, it is fitting that we honor our Native members and Wisconsinites with a justice-focused reading, Justice for the Land and Peoples. This comes to us from the League's Community Alliances Committee. Land acknowledgement. Today, as we meet across the state of Wisconsin, it is important that we acknowledge that this land was occupied by many peoples long before it became Wisconsin. Many indigenous peoples walked and lived in this area long before European and US Americans made their way and their stay. Ho-Chunk and Menominee are the longest consistent settlers, as they and their ancestors were put here by the Creator. There are 9 other federally recognized sovereign American nations here in Wisconsin, as well as the brother town, who is not yet federally recognized. By acknowledging that we are meeting on the traditional land of these sovereign nations, we honor with gratitude the land itself and all of those other creations who throughout the generations ensured a safe and welcoming place for us today. We can only hope that in many years to come, we will be part of those who are thanked for ensuring a safe and healthy home for all peoples. Next slide. This evening, we highlight Wisconsin issues involving diversity and partnering in nonpartisan advocacy. The League member whose memory we honor with tonight's keynote is Zabel Malkasian. A Milwaukee County resident keen on justice for women, Zabel worked in League to see Wisconsin's marital property reform legislation become reality in 1984. In the late 1980s, Zabel served on the Governor's Council on Affirmative Action. So it is fitting that tonight's Malkasian keynote features a person whose career affirms the right of voters to have their votes count equally in our representative democracy. Melanie Ramey, past State League President and current Vice President, will now introduce our keynote speaker. Melanie?
Thank you, Louise. You know, each year when we choose the topic for the Malkasian lecture, we try to choose a topic that's both timely and important. And this year, we were able to combine 2 topics because we have a true expert with us this evening who is able to discuss the topics of gerrymandering and voter suppression. Douglas Poland is a partner in the Madison law firm of Stafford, Rosenbaum. There he co-chairs their election and political law team. He is also a co-founder and litigation director of Law Forward. And Law Forward is a very interesting nonpartisan nonprofit organization that he co-founded with one of his law partners, Jeff Mandel, last year. And it is committed to the concept of preserving representative democracy in Wisconsin, certainly something that we are all very interested in also. He has also been the lead counsel on a number of important cases involving gerrymandering and voter suppression. Mr. Poland is a graduate of Northwestern University and Loyola University Chicago School of Law, summa cum laude. I would also mention to you how this program will proceed in terms of Mr. Poland's presentation. After that, there will be a question and answer period. If you look at the bottom of your screen, you'll notice the chat icon. If you will click on the chat icon, it will open up the chat screen to your right. And on that screen, you can put any questions that you have that occur to you during the presentation. At the end of his presentation, I will ask him the questions that you have posed. I would also comment that after his presentation and the question answer period, you will then go into the breakout sessions that you chose when you registered. Now, this will take 2 or 3 minutes, and probably the breakout sessions will not start till about 7:40, as you will be put into them in the different rooms. So would also tell you that at the breakout session's conclusion, that will be the end of the evening's program. But we didn't really come for that particularly, in that we have come especially to hear Mr. Douglas Poland. And so without further ado, I will present him to you, Mr. Poland.
Melanie, thank you very much for that kind introduction. Thank you as well, Luis, for your words at the outset. I'm going to share my screen here that has my presentation. The issues of diversity and inclusion are ones that I'm very committed to in many ways as well. And as part of that, I've been somewhat well trained by some of my younger colleagues that when we get onto video presentations for people who maybe have some difficulty with eyesight, we should describe ourselves. And so I am a white man. I'm 55 years old, as my receding hairline shows. I do have black hair. And tonight I'm wearing a blue jacket with a white shirt and a green tie. And with that, I will start the presentation. Well, it really is an honor to be asked to present to this group tonight. I know sometimes we'll hear people say that, but this group in particular, the League of Women Voters of Wisconsin, is so critical to the preservation of our right to vote in Wisconsin. The work that you all have done collectively throughout the state over the years is really truly remarkable and really desperately needed. The work that you've done in information and advocacy for voters. So I congratulate you on that work. I honor you on that work. It's wonderful work. And it has been my very good fortune to work with the League as a lawyer representing the League of Women Voters of Wisconsin in a number of different lawsuits relating to the attempt to purge voters from the rolls in Wisconsin, election law cases last year, and working with the League also on redistricting. I'd like to give a very brief plug for Law Forward. As Melanie mentioned, my Stafford law partner, Jeff Mandel, and I launched Law Forward last October, and we've been quite busy. We have one staff counsel, that's Mel Barnes. We were fortunate to hire Mel Barnes. She'd been at Planned Parenthood of Wisconsin for a number of years. Mel is really a tremendous lawyer. She's very talented. We were lucky to get her. And I was lucky to have Mel help me out with the slides for tonight as well. So I want to give a shout out to Mel for that effort. I think that Melanie did a nice job of describing what Law Forward is. We are a law firm that is a nonpartisan, nonprofit law firm that is dedicated to protecting our democratic institutions in Wisconsin and building them back, frankly, to where they had been in the past. We're in the long haul. We're not here just to be here for the next couple of years. We would like to stick around for 15, 20 years or even longer, and look forward to a long working relationship with the League. There are the topics that I'm going to address tonight. It'll be a summary. These are very deep and involved topics. To talk about these, we could take a few days. So I'm going to give an overview of them. And I want to talk just generally about voter suppression, but then really get into the meat of the matter on partisan gerrymandering and redistricting as a specific form of voter suppression. But really, voter suppression, as we've seen it in Wisconsin and around the country, is something that happens because politicians who are not able to convince voters that they should vote for those particular politicians over the past decade in Wisconsin and around the country more recently have engaged in a number of tactics really that stacks the deck in their favor and against voters. And this has taken a number of forms that we've seen in Wisconsin. We've seen limits on voter registration, the time that voters can register, the locations that voters can register, a number of different ways of narrowing down voter registration instead of increasing voter registration. We've seen that in the form of voter ID requirements, very stringent voter ID requirements. And I know that the league is quite familiar with those. We know that certain voters, for certain groups of voters, especially our BIPOC voters, our BIPOC communities, are especially impacted by many of those voter ID requirements and other restrictions. Voter suppression in Wisconsin has taken the attempted form of voter purges. A case, Zignego versus the Wisconsin Election Commission, is a case in which I represented the League of Women Voters of Wisconsin along with the Fair Elections Commission. That was an attempt, of course, to try to purge the rolls of approximately 234,000 voters in Wisconsin. That was a victory. We won that one. We were able to stop that purge from happening. And it was in large part because the league had the resources and the fight in them to make sure that that didn't happen. So that was something that was averted, but probably will come again in another form. Felon disenfranchisement, prison gerrymandering fall under the general category of attempts to try to keep people who have been incarcerated from voting once they're off paper, and to try to gerrymander in ways that count people who are currently incarcerated as voters in the counties where they're incarcerated rather than their home counties, their home locations. And again, it's a way of really suppressing their ability to participate in our democracy. And we've seen also very recently restrictions on absentee voting and voting by mail, including not only in the elections last year, held under the very difficult circumstances of a pandemic, but now in many of the bills that are pending before the Wisconsin legislature that would really cut back the right of Wisconsinites to vote by absentee ballot, which have of course proved to be very popular, especially during the pandemic. So these are forms of voter suppression that we've seen, really pernicious attempts to restrict the right to vote. And I'd like to get now into very specific forms, or one of the specific forms of voter suppression, and that's partisan gerrymandering. And partisan gerrymandering, we can sort of sum it up by saying, this is when your vote is counted, but your vote really doesn't count. And partisan gerrymandering is something that happens, it grows out of the process of redistricting. And you've probably all heard quite a bit about this in the past several months because 2021 is a year in which we are redistricting. Why do we redistrict, and what does redistricting refer to? Redistricting is really the redrawing of state legislative, congressional, and local district boundaries. We redistrict once every decennial cycle, and that is because a federal census is taken in every 10 years. So 2010 was the last federal census. We had one taken last year in 2020. And there was a series of cases that came out in the 1960s, we call them the one person, one vote cases, where the United States Supreme Court determined that we needed to have population equality among the various districts that we draw, state legislative districts, congressional districts, and even local representative districts, such as our different county supervisory districts and our municipal districts as well. So we have to have population equality. Those populations change over the decade and they have to be rebalanced. And so that's why we draw new lines every 10 years. So now when we do redistricting, when we redistrict in the year following the decennial census, we have specific requirements, legal requirements that govern the way that we go about redistricting. There are some that are statutory, and there are some that that arise out of constitutional principles. So one of the constitutional principles that we have is that we need to have roughly equal population. And this is in the state legislative district maps that I'll refer to now. And by that, there is a presumption that if the state legislative districts are within 10% of one another from the top to the bottom, then there's a presumption that they meet the constitutional requirement of one person, one vote. Under Wisconsin state statutes, the state legislative districts need to be contiguous, they need to be as compact as practicable, and they need to preserve our political units such as wards, municipalities, and counties when possible. There are other requirements that, that districts have to meet. They have to comply with the Voting Rights Act of 1965, so they need to create opportunity districts for, or majority-minority districts where they can. And then they have to comply with other federal constitutional requirements. So for example, racial gerrymandering. We can't have a racial gerrymander that would violate the federal constitution. There are other traditional, what we call traditional redistricting criteria. These are not statutory criteria. They're not absolutely mandatory, but these are criteria that courts will consider when they're looking at maps that come in front of them as part of the redistricting process. And the most important of these is really communities of interest. And what communities of interest refers to is people with common concerns that they should be able to be represented in the same legislative district. So we like to try to keep areas where people have things in common. We want to keep those within the same legislative district. We don't want to run, for example, a legislative district boundary down the main street of a downtown of a specific town. So we're splitting that downtown area. If we know that there is a community where we have a large group, a large community that shares something specific, where they would like to be represented by the same representative in the legislature, we don't want to divide that community of interest up. So that's something that gets considered as well by courts as one of the traditional criteria. So what is partisan gerrymandering? Partisan gerrymandering is something that's been around for a long time. People may have heard this before, but basically it goes back, the term itself, gerrymander, goes back to the 1812 election, or 1812 election in the state of Massachusetts. And it's where the governor, Elbridge Gerry, that's pronounced with a hard G, Gerry. And some people insist on pronouncing gerrymandering as gerrymandering. And I guess that's technically the correct pronunciation, but we don't hear that very much. Elbridge Gerry helped to draw a district that one of the local papers said looked like a salamander. And so Elbridge Gerry, you combine that name with the district looking like a salamander, and you get gerrymander out of that. That's where the term comes from. But basically, partisan gerrymandering is the deliberate drawing of district lines to give a systematic advantage to one political party over another political party. That at its base is really what a partisan gerrymander is. There can be other kinds of gerrymandering. I mentioned before racial gerrymandering, and that is where you might draw a district line so they specifically advantage, or more likely, more typically disadvantage specific racial groups. So that's partisan gerrymandering. So how do we gerrymander? How do we actually go about the process of gerrymandering in giving that partisan political advantage to one specific party over another? It's done by two methods called packing and cracking. Let's say that we have 50 precincts or 50 voting wards or 50 districts within some kind of a legislative body. And let's say that 40% of that population tends to vote for the teal party and 60% tends to vote for the blue party. If you just had a straight election, obviously the blue party, and you had a straight translation of vote share to seat share, and 60% of the voters voted for the blue party, you would have 60 seats in the representative body that would be held by the blue party. And so the blue party would have an advantage over the teal party. But through gerrymandering, through these techniques of packing and cracking, you can actually, the teal party, if they can control the process, can actually have a majority in that representative body. How do they do it? Well, they do it by packing and cracking. And they pack and crack districts so that teal can actually gain an advantage. They can have more of the districts than the blue party. First of all, packing. This may be a term that you've heard before. This is where the party that controls the process of redistricting can pack all of the opposing party's voters into specific districts. So if it only takes 51% to win a district, you can pack that specific district with, let's say, 76, 77, 78 or more % of the opposing party's voters. That way you're wasting that other party's votes. So we're going to pack, as you can see here in districts 4 and 5 on your screen, we're going to pack blue party voters into those 2 districts. So there are more than enough blue voters to actually win those districts. Those are safe districts for the blue party. And at the same time, we're going to crack districts 1, 2, and 3. We're going to put just enough teal voters in there that the teal party can get a majority. So maybe 51 or 52% advantage for the teal party. We're efficiently distributing the teal party's votes. And when we do that, when we pack and when we crack, we can get a majority of districts that are held by the teal party, districts 1, 2, and 3, versus only districts 4 and 5 held by the blue party. So even though the blue party has a majority of voters, the teal party controls that representative district. And that's exactly what happened in 2011 with the Wisconsin, the way the Wisconsin legislature went about gerrymandering the legislature. And let me give you some examples. On your screen here, you're going to see, this is actually, these are examples of packing and cracking in districts in Wisconsin. This is a graphic that we used in a brief to the Wisconsin States, I'm sorry, to the United States Supreme Court. Over on the left, what you see is a composite of the current map. The current map, what that means is that was the districts as they were composed in 2002, those district boundaries in 2002. But they reflect the population as of the 2010 census. And so in 2011, when the legislature redistricted, if they had left the district lines from 2002 intact, what you see there, out of those 2, 4, 6, 8 state legislative districts as they were drawn in 2002, using 2010 census data, you would have had 4 state assembly districts in the Milwaukee area that would have been won by the Democratic Party. You would have had 4 districts that would have been won by the Republican Party. And so you would have had 4 and 4 in the state. It would have been an even split in the state legislature. But by packing and cracking voters in the Milwaukee area, the Republican legislature was able to design those districts so that there were 6 majority Republican state legislative districts and only 2 majority Democratic districts in the state legislature. So as you can see, they did this primarily by cracking those districts in Milwaukee that had heavily Democratic voters. Districts 13, 15, and 7, as you can see, as they were drawn on the left of your screen in 2002, they extended districts 13, 14, and 15 over into those blue areas, and they cracked those districts. They pulled those Democratic voters into majority Republican districts where their votes were diluted. And so as a result, the Republicans got 6 legislative districts in the Milwaukee area to only 2 for the Democrats. They did the same thing in the lower part of the screen, as you can see in Kenosha and Racine counties. The lower left-hand portion of the screen, you can see, again, had the district boundaries stayed intact from where they were in 2010, you would have had 2 Republican districts in the assembly and 4 Democratic districts, but the Republicans were able to pick up 1 seat there in the assembly by cracking those districts in those heavily Democratic districts in Racine and Kenosha, and pulling those voters into the Republican majority district. So that's how they cracked and they packed. Now, partisan gerrymandering had never been held to be unconstitutional by the United States Supreme Court. So in 2015, we filed a lawsuit in the federal court in Madison. You may have heard of it, called Whitford versus Gill. And this was an attempt to have partisan gerrymandering declared unconstitutional under the federal Constitution. There had been many cases that had been filed before that addressed that issue, but none had ever actually held as a matter of law that partisan gerrymandering was unconstitutional. And so this was a case that we filed trying to get that outcome. So this was a challenge to the 2011 Wisconsin Act 43, the state legislative districts that were put in place by the Assembly by the state legislature in 2011. The outcome of that case really was we won at the district court level. We appealed to the United States Supreme Court, ultimately lost that case, but I want to run through it because it's illustrative of how partisan gerrymandering is harmful to our democracy. As I mentioned, the United States Supreme Court had never held partisan gerrymandering to be unconstitutional. And they had held that largely in part, not because they thought that it was okay, not because they thought that it was not a problem under the federal constitution, but because a majority of justices had never been able to find that there was a particular standard that could be employed by courts, by federal courts, to decide when a state legislature went too far in putting in place a partisan gerrymander. The courts have always recognized that redistricting is primarily a function of the legislature. It's primarily a political function. And so the courts have been very reluctant to get involved. They only want to get involved when a legislature goes too far. When the legislature's, let's call it right, or ability to be able to redistrict pursuant to its political functions, when that goes so far that it actually impedes on the constitutional rights of voters. Where do you draw that line? And that's something that the United States Supreme Court hadn't been able to figure out. They'd wrestled with that issue for 30 years by the time we filed our lawsuit in 2015. They'd never been able to identify a legal standard. And so what we proposed to the court was a new legal standard that we wanted the court to adopt, by which it would determine whether a particular partisan gerrymander was actually illegal. And we proposed a three-part standard. We said that to prevail, to show that a particular legislative district plan was unconstitutional, we should have to show that there was an unconstitutional partisan intent by the legislature, that that intent actually played out and had an effect that was unconstitutionally partisan, and that there was no neutral justification that could possibly explain why it was okay to draw the districts the way that they were drawn. So the first prong that we proposed of this standard was that we should have to show partisan intent. We tried this case to a 3-judge federal panel in the federal court in Madison in 2016, in the spring of 2016. And so what we were able to show that panel was that there was a deliberate attempt by the state legislature in 2011 to actually engage in a partisan gerrymander by squeezing as many districts as possible out of the legislative plan that would vote in favor of Republicans as they could. In other words, to maximize the translation of the vote share for Republicans to the seat share in the assembly. How did we do that? Well, we got through the discovery process, we got copies of the hard drives that were used by the state legislature in 2011 to actually conduct the legislative redistricting. And when we did that, when we got those hard drives and we had them analyzed by a computer forensic expert, what we found is that there were a series of spreadsheets that were created by the legislative aides who drew these maps. Through these spreadsheets, through this process, we were able to show that they would create maps, they would draw district boundaries, they would then run them through a computer algorithm that they had created to try to project what the partisan outcome of that legislative district map would be under a vote using actual results of elections in the past. And then they would decide whether they were going to stick with that map or whether they were going to try to change it. So they started out using just the districts as drawn in 2002. So they used those districts. This is shown on your screen here as the 2002 plan. And then this is a graphic that we created. This plugs in the 2010 census data, just like the previous map that I'd shown. So if in 2011, if the state legislature had just kept the legislative districts intact using the 2010 census data, the Republicans would have won, or would have been projected to win by their own calculations, 50 out of the 99 assembly seats. They would have had a 1-seat advantage in the Wisconsin State Assembly. And so the map drawers in 2011, this is what they did, and they saw that. They saw that they would have a 1-seat advantage, but they didn't stop there. They drew another set of districts. And this is one that we pulled again from the hard drives. This is Handrick map number 11. The Handrick is a name that they gave to this map, and that's because this is a map that came off of a computer that was used by Joe Handrick. Joe Handrick was a consultant to the state legislature in 2011. And this came off of a computer that he had been using. So this is a map that he drew. And this map, as you'll see, is one where Handrick was able to draw it so that there would actually be a projected seat share that the Republicans would have in the state assembly of 53 seats. So just by changing the district lines and rerunning that algorithm, there is a projection that this map would yield a vote or a seat share of 53 out of the 99 assembly seats for the Republicans. But they didn't stop there. They kept on drawing different district lines. This is one from Handrick. This is map number 9. This one he drew, Republicans could get a 54 seat share in the assembly. This is one that came from legislative aide Adam Foltz, and this is his map number 48. He drew a map that was projected to result in 56 seats in the assembly for the Republicans. And we can go on and on. This came from legislative aide Tad Ottman, who was retained by the Republican caucus in the Senate. He drew a map that would projected the Republicans would win 57 seats in the assembly. They kept on doing this over and over, as we showed to the court, until they got to one where they were projected to win 59 seats, and that's what they ended up adopting. They proposed that in the assembly and the Senate, and that's what they adopted. So we built this graphic at trial, which shows the projection from left to right, where if they had just started out with a 2000s map, and that basic one I showed you, they would have a 1 seat, the Republicans would have won a 1 seat majority in the assembly. But they kept on tinkering and adjusting and tinkering and adjusting and testing until they got a maximum of 59 seats in the assembly. They plateaued there. They felt they couldn't get any more. And then that's what they ended up with in the final map. So that was to show partisan intent. And the court, of course, found that we certainly showed there was an intent by the legislature to redistrict in a way that would advantage Republicans over Democrats. The second prong that we proposed of our 3-part standard would be to show the partisan effect. And again, if what we showed before didn't show the effect, then the way that we showed it tried to show it was through something called the efficiency gap. And this is a term that you might have heard about before. The efficiency gap is really a way of measuring, a mathematical formula to measure what we call wasted votes. And I referred to that wasted votes a little bit earlier when I was talking about packing and cracking. The idea is you want to, as the party trying to gerrymander, you want to efficiently distribute your own votes as much as possible and waste as many of your opposing party's votes. And you do that through packing and cracking. So we wanted to show that there was an efficiency gap, that Republicans had wasted Democratic votes as much as possible, and that the gerrymander that they put in place was not only significant, it was not only substantial in favor of Republicans and gave them a significant advantage, but it was durable and designed to last over the entire decade. And this is a graphic I know that isn't going to mean very much to you in the way that it looks, because you probably can't see very much on this map or this chart. But essentially what it shows is a distribution of different state redistricting plans between 1972 and 2014 as measured by the efficiency gap. And so that straight line down the middle indicates a neutral map. That would be an efficiency gap of 0. That would be a plan that doesn't waste any votes. It's not pro-Republican, it's not pro-Democratic, it's just a neutral map where you're not wasting votes on either side. Everything to the right of that dark line is an efficiency gap in a plan that favors Democrats. And so as you can see, it certainly is true that between 1972 and 2014, there were legislative districting plans in different states in the United States where Democrats gerrymandered. It happens on both sides. Democrats have done it in the past. They've done it before. And that shows distribution of state legislative district plans where that happened. Over to the left those show state legislative districting plans where Republicans have gerrymandered over the years between 1972 and 2014. In the lower left-hand corner, you'll see there's an oval there that's drawn, Wisconsin Act 43. That's 2011 Wisconsin Act 43. It was the 4th most extreme partisan gerrymander in the United States among the 50 states between 1972 and 2014. And this was a chart that was created by one of our experts, Simon Jackman, who's a political scientist at the time at Stanford University. And so we showed that to the court to show them that there was, in fact, a partisan impact. And this gets to the issue of what we call partisan symmetry, or in this case, partisan asymmetry. And what we mean by that is a deliberate skewing of the partisan advantage to favor one party. If we have partisan symmetry, then we have an equal opportunity by the different political parties to win a district or to win a districting plan, a state legislative districting plan overall, to win a majority in the legislature, an equal opportunity. It's not a direct translation of vote share into seat share. It's just the equal opportunity to be able to do that. So that if a 48% vote share by one party is enough to give that particular party a majority of seats, then the same should be true for the opposing party. The opposing party should be able to win a majority of seats if it wins 48% of the vote, right? The idea is competitive elections. And instead what we had here, and again, we showed this to the court, is there is a tremendous asymmetry caused by Act 43. In other words, if the chart in front of you, you see a balanced plan in the middle. If Act 43 were a balanced plan, then you would have had a partisan score that would have been balanced. It would have been right in the middle. But instead, there was a 12% pro-Republican advantage in Act 43. You can also see, and that's on a website called Plan Score. And if you haven't gone there, you should, because they score all the legislative and congressional districting plans in the United States on the score of partisan symmetry. Again, showing partisan asymmetry. If this came from this was a footnote in the court's opinion in 2016, where it looked at the percentage of vote received and the number of seats won. These are the projections that the legislature projected. This is taken from the legislature's own documents in what they had projected. And so if you look here, what you'll see is they projected under their plan that if Democrats won 47% of the votes in state legislative elections, they would only win 33 seats in the state assembly. And their same approach, they projected that if Republicans won 47% of the votes, they would actually win 50 seats in the assembly. And you can go right on down the line, and you can see that there's a tremendous asymmetry here in the plans as they were drawn by the Republican majorities in the legislature, so that they would be assured of winning the assembly. So a tremendous partisan asymmetry. And as I mentioned before, it wasn't sufficient, we said, as part of the test, that we should have to show that there was a large asymmetry. We said it should have to endure over a long period of time. And in fact, it has over the decade. As you see here on the screen in front of you, no matter what, no matter how few vote, no matter how low the vote share Democrats win, whether it's 45% of the vote or 53% of the vote, they really can't get more than 39% of the seats in the assembly under Act 43. And no matter how poorly the Republicans performed here over the course of the decade, whether it's 44.75% of the vote or 52% of the vote, they can't win less than 63% of the seats. That endured throughout the entire decade. So again, we certainly showed that that was a durable gerrymander, and the court agreed with this as well. The third prong of the test that we proposed, that if we could show those first two, the burden should shift then, and we should have to show that there's no neutral justification for the plan. In other words, that there was no real, the burden should shift to the other side, to the state legislature or the elections commission, to show that there is no neutral justification for their plan. Now, they attempted to show that, and the defendant there was actually the elections commission, although the legislature became a party in the lawsuit later on. They attempted to show that there was actually an innocent explanation for that tremendous pro-Republican advantage. And what they said is that, well, what we call the political geography works in favor of the Republicans and against the Democrats. They said that because Democrats are concentrated in a few areas like Milwaukee and Madison and a few other regional cities, that they gerrymander themselves. Democratic voters gerrymander themselves, and Republican voters are really spread out throughout the state. And so therefore, that's what causes this asymmetry. Well, what we were able to show through the work of a political scientist named Joey Chen, who's at the University of Michigan, is that that actually doesn't hold water. It is true that there is a small pro-Republican advantage caused by this political geography, but at that time, it was only a little bit more than 2%, not that 12% advantage. And one of the ways that we showed that is that we had Joey Chen run, or I should say Joey Chen ran a series of, I think it was about 200 in this instant, 200 computer simulated districting plans. In other words, not controlling for partisanship, not trying to make a district partisan, just using those redistricting criteria and drawing districts. And after he ran those districts, he came up with a distribution of how they scored in terms of partisan symmetry. As you can see here on the screen, all those red circles, that's the distribution of those 200 plans as they were scored by the efficiency gap. And as you can see, they're all pretty much grouped over there together in terms of how they come out. They all show there's a distribution there of between about 2.5% pro-democratic to about a 6% pro-Republican. That's the negative part of it. Advantage in the state assembly. But as you can see in that lower left-hand corner, that's an extreme outlier, right? Act 43 is an extreme outlier. And so if there were an innocent explanation here, you'd expect to see Act 43 grouped right in the middle of all of those red circles on your screen. And in fact, it's an extreme outlier. And so we showed there really is no innocent neutral justification for Act 43. Now, the court agreed with us. The 3-judge panel agreed with us. They issued an opinion in November 2016 in our favor. They found Act 43 to be unconstitutional, and they enjoined it, and they gave the legislature and Governor Walker at that time until November 1st, 2016 to come up with a new state legislative districting plan. The Wisconsin Elections Commission, supported by the state legislature, appealed to the United States Supreme Court. And so we went to the United States Supreme Court. Photos of the legal team over there on the left, or some of us at least. That's me over on the left. Next to me is Annabelle Harless of Campaign Legal Center. Next to her is Nick Stephanopoulos, who was a professor at the time at University of Chicago, now is at Harvard Law School. Nick was one of the creators of the efficiency gap and was a member of the trial team. Next to Nick, to his left, is Ruth Greenwood. She was at the Campaign Legal Center at the time as well, and now is at Harvard Law School. She and Nick are married, and they just founded the Harvard Elections Clinic, first elections clinic in the country. And then next to Ruth, to her left, is Eric McGee, a political scientist who, along with Nick Stephanopoulos, came up with the efficiency gap. And then over on the right is a photo of a number of our key plaintiffs and some members of the legal team. And there we are on the steps in front of the United States Supreme Court. So we argued it in October of 2017. We got a ruling in the spring of 2018. And it wasn't a win. It wasn't necessarily a loss. It was sort of a neutral ruling. What the court held actually is that we as plaintiffs didn't have standing to bring the claims. And so they didn't say, we think that the district court was right. We don't think that they're wrong. Really what they found is that we didn't present adequate evidence to show that each of our plaintiffs had an injury. In other words, we didn't show that each district in which a plaintiff lived was packed or cracked. And that was something that we had to show. So they sent the case back down to the district court for a new trial. And so we went back down to the district court and we started to take that evidence so that we could have a new trial. So we filed an amended complaint. We added a number of additional plaintiffs around the state. And we were scheduled for a trial in July of 2019 that we were confident we were going to win. And then we got a ruling, or there was a ruling from the United States Supreme Court in June of 2019, the month before we were scheduled to retry the case. That was a ruling in a case called Rucho versus Common Cause, a case very similar to ours. And actually a number of those lawyers, Ruth Greenwood, Annabelle Harless of Campaign Legal Center, and Nick Stephanopoulos were involved in that case. That was the case where the Supreme Court dealt the death blow to bringing partisan gerrymandering claims in federal courts. And there, the United States Supreme Court held that partisan gerrymandering claims are not justiciable in federal courts because they present a purely political question that federal courts are not able to reach. And so you might say, well, what happened just 1 year before? The United States Supreme Court seemed to say, gosh, these claims can be adjudicated because they sent us back down to the trial court to give us another shot at proving our claims. If they thought at the time those claims couldn't be adjudicated, then they should have just held at the time they couldn't be adjudicated. What changed? Well, what changed is the makeup of the court. We had a different court in the previous ruling. In our case, we had, as you can see, Justice Kennedy over there, the second from left. Justice Kennedy retired, and in his place, we had Justice Kavanaugh. Justice Kavanaugh is on the far right of that picture, and Justice Kavanaugh voted with the other four conservatives on the court, Justice Roberts, Thomas, Alito, and Gorsuch. And so that was the death knell to being able to bring partisan gerrymandering claims in federal court. So in the wake of that decision, what legal avenues remain to challenge partisan gerrymandering in the courts? Well, we could bring a partisan gerrymandering claim theoretically under the Wisconsin Constitution. It's never been done before, but there are many of the same types of constitutional provisions in the Wisconsin state constitution as we have in the federal constitution. We have a free speech provision. We have an equal protection provision. We have a freedom of assembly provision. And then there's also a different provision called the free government provision that we have. So those are all potential candidates under which challenges could be brought to a partisan gerrymander under the Wisconsin Constitution. There are also other grounds that we could challenge new legislative districts, not necessarily a gerrymandering claim, but other claims to districts as they're composed. So in the state courts, we could bring claims under the state or the federal constitution. In federal courts, we could now bring claims under the Voting Rights Act, Section 2 in particular of the Voting Rights Act. And we won a claim under Section 2 of the Voting Rights Act in a 2011 lawsuit where we challenged the makeup of legislative districts in Milwaukee. And we were able to get majority Latino districts, 2 majority Latino districts in place there under the Section 2 of the Voting Rights Act. That's Section 2 allows or requires majority minority districts to be drawn, opportunity districts to be drawn where they can be. We also would have racial gerrymandering claims that we could bring in federal courts under the federal constitution. And of course, there are always legislative options where legislative districts could be drawn. There could be a constitutional amendment that could be put in place to draw state legislative districts differently. In addition, there could be new federal statutes that could be enacted that would require state legislative, I should say federal congressional districts to be drawn in a different way that could eliminate partisan gerrymanders. What else could be done? What else could be done to cause fair districts to be drawn? Well, there are process reforms that could be put in place. So for example, you've probably heard something called the Iowa model, where they have a nonpartisan commission that draws state legislative districts. There are nonpartisan commissions or bipartisan commissions that exist in different states, and that's something that could be done. That would actually require, that could be done legislatively. Ultimately, if it were to be done by constitution, it's something that would require a vote of the legislature. Then there would have to be an intervening election, and then there would have to be another vote in the legislature, and then it could be adopted as a change to the Constitution of Wisconsin that would require a commission to draw legislative districts rather than the state legislature, which is how Wisconsin law requires it to be done now. There are other enforceable standards that could be put in place as part of that or by the legislature. For example, no partisan gerrymanders could be part of the standard. There could be competitiveness standards. Remember, again, I said before that one of the aspects of a partisan gerrymander, this packing and cracking, is that it creates districts that are packed where you basically have safe districts that are not competitive districts. We could require districts to be competitive. We could also have communities of interest actually put in as a standard, as opposed to simply a consideration that could be considered, but is not necessarily a legal standard. I also briefly wanted to touch on the redistricting timeline that's in place now for 2021. In April 2020, the census began to be taken. On April 26th of this year, the apportionment data was released to the states. Typically, by the end of March, the apportionment data, those are the data that are used to actually reapportion the seats in the United States House of Representatives. They're not used to actually engage in the process of redistricting within the state. But in a typical year, following the census, all census data for apportionment purposes and for state legislative districting purposes are released by March 31st. That didn't happen this year because the Biden administration came in and said that the census data were a bit of a mess and they needed to be fixed before they could be released. So on April 26th, the apportionment data were actually released, and the best estimate that we've heard right now is by about August 16th is when that data, the PL 94-171 data, that's the data that's used for the process of state legislative redistricting. That's when it will be released to the states, and that's when the process will start. But there are other significant considerations and dates to consider. April 15th, 2022 would be the first day to circulate nomination papers for the partisan primary for state legislative district elections that would be held in the fall of November of 2022. June 1st of 2022 is the deadline to file nomination papers for the partisan primary. August of 2022 is when that partisan primary would happen. And then the general election would happen in November of 2022. Before I get to questions, and I've got a couple minutes here left, you might have also heard, let me just touch on the issue right now of local redistricting, because you've probably heard there have been some issues that have arisen with local redistricting, and there are bills on the floors of the assembly right now to put off local redistricting. So there would be no local redistricting in 2021 and 2022, no new local elections in 2022. They'd be frozen in place until 2023. That is being done or being proposed ostensibly because there's a deadline in December to circulate nomination papers for those local offices, because the primaries would be held in February, and then the local elections, the general elections, would be held in April. And so those are bills that have been proposed. They've been strongly opposed by a number of voting rights organizations and advocacy groups, including the League of Women Voters of Wisconsin. And thank you for your opposition to those pending bills. But those are other deadlines to keep in place. And so with that, I think I've finished about 40 seconds early, and I would be happy to take questions that anyone has.
I think I was muted, probably by popular demand. But in any event, the question was, or the comment was, that it seems that in the packing and cracking, that it seems to favor the extremes in both counties. And so it doesn't really turn out to have any competition between the two parties, but just competition within parties is what that results in.
Well, that's correct. And that's essentially what we've seen in Wisconsin. So this is the idea of competitiveness that gets fostered when you eliminate partisan gerrymanders. So what you end up getting is you end up getting more extreme candidates who are running, because the races become all about the primaries as opposed to the general election. And so then, as we've seen, if you look at the number of state legislative districts around the state where there is no candidate running for one particular party, one of the two majority parties, the seats have been designed to be so safe for one of the two parties that all of the action is in the primaries.
Yeah.
And so we get these very extreme candidates who take very extreme positions. So it doesn't foster people who are candidates who are running based on policies. They're running based on partisan affiliation. So it really drives those policy discussions to the margins. And that's one of the real problems. And we see that reflected in the policies that come up in the legislature as well, and the positions that the legislature takes.
The next question is, realistically, what can those of us ask friends and relatives? Wait a minute. It went away here. Okay, wait just a minute. Okay, in making new maps, there is a built-in natural packing of Democrats in Milwaukee and Madison. Without addressing this with voting data, how will it be possible to get to 50-50? Presently, the People's Map Commission and the Assembly Dems bill will disallow the use of voting data.
So let me address that in a couple of different ways. I think so. The idea of having a perfectly neutral map is not necessarily something that that would meet the idea, or having a partisan symmetry of zero, or an efficiency gap of zero, wouldn't necessarily meet the criteria of a neutral map. In other words, as I mentioned before, the political geography of the state is not perfectly neutral. It's not exactly zero. And so you might expect that if you had a very neutral map, that there would be a slight pro-Republican tilt to that map. And just as if you went down to Illinois, and if you went through the same exercise in Illinois, you might have a map that would be tilted slightly in favor of the Democrats. And so there's not this idea that there would be a perfectly neutral map. But the point is that that advantage would be dramatically reduced, right? It would be dramatically reduced. And so it would make for much more competitive elections.
Yeah.
And the second part of the question, Melanie, if you can remind me of that again, I'm sorry.
Okay, and it's, let's see.
Oh, I remember.
Oh, okay, yeah.
I remember.
It says, how will it be possible to get to 50-50? Presently, the People's Map Commission and the Assembly Dems bill disallow the use of voting data.
Yeah, so it's important. I want to be clear about this. It's important when you are drawing districts that you be mindful of what the partisan implications of those districts are. Mm-hmm. It would not be helpful to turn a blind eye to that. So if you were simply to sit down and you were to redistrict using the criteria I put up on the screen before and say, we're not going to consider partisan impact at all of what we draw. We're just going to have tunnel vision. We're going to use these and let the chips fall where they may. You could inadvertently create an extreme partisan gerrymander. So it's one thing to say, we're going to actually draw the districts without regard to whether it results in a specific partisan outcome. That part of it is okay. That part of it is fine. But in the end, when you're looking at a map to recommend, you have to know in advance what the partisan impact is of that plan that you're drawing, because you don't want it to have an outsized partisan advantage in favor of one party over another. Hopefully that makes sense. And so that's why you have to be mindful of it. You have to be cognizant of it so you don't stumble your way inadvertently into an extreme partisan gerrymander.
Okay, the next question is, realistically, what can those of us ask friends and relatives who live in Republican districts to advocate for? And when would it be effective to ask them to contact their Republican Assembly representatives or senators?
So we get the question a lot, what can we do? What can we actually do? What can the average person do? And it's easy to sort of throw up your hands and say, well, if the fix is in that badly, what can we actually do when the courts aren't helping us? And we certainly understand that, that feeling of frustration, that feeling of futility. But you have to keep fighting. We all have to keep fighting. We have to keep doing what we can. In 2011, this all happened under a cloak of secrecy. And that was by design. I can tell you that in 2011, you could have heard a pin drop. When we went to litigate the challenge to the redistricting plan at the time, there almost nobody cared. Almost nobody was paying attention. It wasn't on the news. Nobody heard about it at all. Contrast that to where we are now. And this is an issue that there has been awareness raised throughout the state. There are people who care passionately about this issue and have made their voices heard. I heard from two friends of mine after the Women's March in 2017. They wanted to know what they could do. I sat down and talked to them. They went out and they started a whole new organization to push forward to try to get fair maps in place. So let me start out by saying that, that there are a few different things that can be done. So first of all, there is a Fair Maps Coalition that hopefully you're all aware of. The League of Women Voters of Wisconsin participates in the Fair Maps Coalition, or FMC. Hopefully you all know about it. If not, maybe somebody can share a link to the Fair Maps Coalition website. They put out a lot of information. They put out a lot of opportunities for people to participate. And that is something that, that you all can do. You can follow Law Forward on Twitter and Facebook. You could go to our website. It's www.lawforward.org. You can sign up to receive our emails where you'll be notified of different ways that you can become involved. And you can follow along with what happens in court or pre-court filings. We also have a Redistricting 101 publication that we came out with last one. That's available on our website as well. If I were a little bit more proficient at this, I could probably figure out how to post that in the chat feature. You can also, as part of the People's Maps Commission process, you can actually get on the PMC website and you can draw your local community, a community of interest that you want on a map. And this one I actually, Mel Barnes, my colleague at Law Forward, has helped me to do. I'm going to see here if I can actually paste this now. There is, let me see if I did that. I did that successfully. Look at that. So there's a little message in there about the PMC, and there's a link in there as well. Thank you, Mel, for helping me with that. And so that's something that you can do as well. But really the main point of the message is, please don't give up. Don't give up. Stay strong, fight, keep fighting. Always, we're going to be right in there in the fight with you. Law Forward will stand shoulder to shoulder with the League of Women Voters and all these other constituencies that we represent until the day comes in Wisconsin when we do have fair maps.
Okay, the next question. How can Republicans claim that the state constitution requires the legislature to draw the maps and get credence for that claim when the Constitution really says that the legislature gets to approve the maps?
Well, the first, it's a combination of case law and statute and Constitution that it's true that they do have essentially the first shot. But of course, the way that redistricting has been done in Wisconsin, and there is a state Supreme Court case out there on this, it has to be done through the mechanisms of the legislature. That means through actual adoption of a statute. That, of course, presents it to requires that it be presented to the governor for the governor's veto or the governor's signature, one of the two ways. And so it is a process that's taken up in the first instance by the legislature, but then of course it is subject to the governor's veto. And so this is something that, like many of these other voting bills that are up in front of the state legislature right now, those have to be presented to the governor under the presentment clause of the Constitution. So in an ideal situation, and when I'm asked about this, and asked about what a victory would be, what a win would be for the people of Wisconsin in this redistricting cycle, I often answer that I think a return to normalcy would be a win for the people of Wisconsin. In other words, our system of government has been so broken over the last decade. We've seen such a lack of bipartisan efforts to really do from a policy standpoint what's best for the people of Wisconsin, and instead an attempt to aggregate power in a legislature by taking it from the governor, by taking it from the Wisconsin Department of Justice and the Attorney General, and concentrating it in the legislature. That a victory for the people of Wisconsin would be for the process to actually play out like it's supposed to. And what I mean is, if we actually get, once the data are released by the US Census Bureau, if we have the different caucuses in the legislature present competing bills on the floor of the Assembly and Senate, if we actually have robust debate among the members of the Assembly and Senate over those proposed bills, if we actually have real hearings in the Assembly and Senate where the League and others can testify about what they would like to see in the Assembly and Senate bills, if we can actually have a vote on that in the legislature, regardless how that vote comes out, and if it's actually presented to the governor for the governor's signature or veto, and if he vetoes it, if we can actually have a process in the courts by which that impasse is resolved. That return to normal legislative process and mechanisms of government, I think would be a win for the people of Wisconsin.
The next question, if new maps will not be drawn before elections in 2022, could there be a proposition to use the maps drawn in 2001 instead of 2011?
Well, so new districts will be drawn for the purposes of state legislative districts before 2022. They have to be by the constitutional standards that are in place, and that's the malapportionment standard. They require equality of the districts, population equality. The question that's in place right now with these pending bills in the Assembly and Senate has to do with our local districts. That's with our county supervisory districts, and then also with our local alder, as we call them in Madison, alder districts or aldermanic districts in other places. Now, if certain municipalities or counties or the legislature, if it were to adopt legislation that was signed into law by the governor, if those districts were frozen in place, there could be challenges to those districts, those frozen districts, by the same principles, the same constitutional principles. So I see very, very little likelihood, essentially no likelihood, that districts will be frozen in place, whether they're state legislative districts or local districts, for the purposes of elections in the fall of 2022. But that being said, if a court were making that decision on what the districts should look like, certainly somebody could go back to those districts drawn in 2002. But the problem, of course, is now that would be those were based on census data that's now 20 years old. And so it really would be outdated. I find very little likelihood that anybody would want to use those particular district boundaries.
Okay, what alternative timeline to the one proposed by the legislature would be practical?
Well, I think that really depends on how quickly municipalities and let's put it this way, for the purpose of our local governments, how quickly municipalities and counties can act. So, for example, the city of Madison and Dane County, I believe representatives have said quite recently that they will be prepared to adopt new county supervisory district boundaries and new aldermanic district boundaries in the city, based on the redistricting data that's released in August. So they think that they'll be in a position to be able to do that, have those drawn within time for nomination papers to be circulated in December of 2021. But it really depends on how quickly the different districts around the state can do that. There may be some districts that can't, or municipalities or counties that can't do it in time, but it may be that the people who live in those counties are okay with that and that they could freeze their districts in place. So it really depends. I mean, it really is a municipality and county by county basis. For the purpose of state legislative districts, it can be done incredibly quickly. We are light years beyond where we were in 2011 because of these dramatic advances in the ability to use computer algorithms to draw new legislative district boundaries. We can draw, or I should say not me, but these experts can draw tens of thousands of potential alternative legislative district boundaries in entire state maps overnight by pressing a button on a computer. And so as soon as that data is released by the Census Bureau on August 16th, within a matter of days, we can have tens of thousands of potential alternative districts that could be proposed.
This next has excellent presentation. Is there any effort ongoing in Wisconsin to partner with one or more states that have extreme efficacy gaps in favor of Democrats? It would seem that having plaintiffs challenging both parties might bring a greater strength to a case?
What I can tell you is that in 2017, when we went to the United States Supreme Court, that's exactly what we did. We went around the country and we enlisted the support of Republicans. These are elected Republicans who were simply in favor of fair maps and didn't want partisan gerrymandering. We were quite successful in doing that. And just to the south of us in the state of Illinois, where I lived for 20 years and practiced for a long time, there were a substantial number of elected Republicans in Illinois who wanted to get rid of a pro-democratic gerrymander in the state of Illinois. And they supported us very strongly. So the answer is yes, we can go around the country and there are Republicans of good faith in different states around the country who believe strongly in fair and representative government and that there shouldn't be partisan gerrymandering in legislatures to favor either political party.
It says, is the Wisconsin Counties Association in favor of delaying the implementation of new maps for county and municipal districts due to the census delay, or was this bill, AB 369, generated by the Republican majority in the Assembly?
Well, my answer to that question is different as of this morning. There is some excellent reporting done by Melanie Conklin of the Wisconsin Examiner. For any of those who haven't seen it, I urge you to go on Twitter or whatever your favorite news outlet is, or Google it and take a look and read that article. According to Melanie's reporting, this is a highly partisan bill, and it was proposed through the people. One of the people you know, I mentioned the name Joe Handrick before. Joe was involved in 2011 in drawing the Republican gerrymander. He still works for Representative Voss in one capacity or another. And Melanie cited some emails where, as of a few months ago, as a matter of fact, Joe Handrick was at least in part behind these bills that the Wisconsin Counties Association has advanced. So there's a very strong reason to believe that this is a very partisan, these are very partisan bills, that these are, the purpose we can guess at, I don't know, but at least that they're being put forth for partisan purposes.
The next question is, what happens when the GOP legislature passes a gerrymandered map and the governor vetoes it? Is the old map used, or does it go to the courts again?
Well, so that awaits a ruling by a court. The old plan stays in place until there's a ruling by a court that says that it can't be used. And so to go back in time in 2016, when we won the Whitford versus Gill case, and that judgment in November of 2016, or I should say we got a decision in November 2016, the federal court in Madison entered a judgment in January of 2017 that actually put an injunction in place that said to the Wisconsin State the Elections Commission, you cannot use the existing state legislative districts for any elections until there's a new set of districts that comes out that complies with the Constitution. And so from that moment on, it was enjoined. And so let's say that there's a lawsuit filed, and let's say that October 15th, there's a decision by a federal court or a state court that enjoins whatever the districts are that the legislature wants to put in place. Or I'm sorry, there's a ruling that the existing districts are malapportioned. That would be an injunction that would be put in place as of that time. And so as of that particular time when the injunction is put in place, as long as there's no stay of that ruling, that from that point in time, those districts couldn't be used. So it's really dependent on a court ruling that has an injunction that stops the Elections Commission and orders them from not using those districts going forward.